Hi, we're talking about Your Money Matters on NDTV Profit, and my name is Alex Matthew. An important change in the law that relates to inheritance has taken place, and that has to do with one word. It's called a probate. What is this probate? Why did it lead to a little bit of a complication of process? Where was it relevant? And what happens now that the compulsory probate has been pushed out of the window? Joining me to talk about all of those aspects is Shaishavi Kadakia, who's a partner at Cyril Amarchand Mangaldas. Shaishavi, thanks so much for taking the time and wish you a happy new year. Let me start by asking you, what is a probate and why is it relevant in the context of inheritance?
Sure. So, Alex, probate, the word probate is derived from the Latin word to prove. Over the years, over the centuries, this has now come to mean a certificate of a court certifying the genuineness of a will. So, when a person passes away and they have left behind a will, then a court will certify through a probate that that will is genuine.
Okay. So, explain to me in the form of an example how this would take place. Let's say that I have left a will for my imaginary children, and in that case, if I have passed on, in order to execute this will, what needs to be done in conjunction with this probate?
Right. So if you were to leave behind a will, you would name an executor under your will.
Okay.
That executor is someone who implements or executes the will, as we say. After you pass away, the executor can go to a court. If you are in Mumbai, they would go to the Bombay High Court and apply for a probate, saying, look, this is the will. Can you examine it, examine the witness affidavits, and confirm that this will is genuine? It is, it has been validly executed. And because it is genuine, then I can now act on it. Once the court certifies that this is valid, then your executor can go ahead and distribute the assets as per your will to your children. This is what we would, sort of typically look at in a compulsory probate situation, but we'll get to how the law has changed now.
Let's, in fact, talk about that. How has the law changed? And as I understand it, the requirement, compulsory requirement of a probate was only in a few geographies, the old British principalities, and also, as I understand it, in Pune, because somebody just told me, I was discussing it with them, and they said that probate existed in Pune as well. Is that right?
So, Alex, let's break that into three things. So, what is the law? What is it? What has changed? So, interestingly, this is a 150-year-old law that not too many people sort of know about. This provision has existed and now it has been amended. So way back in the 1870s or so, the British decided that for wills of certain religions, there should be compulsory probate in certain geographical locations, like you have said. So what we would examine is three things. Has a person passed away with a will? If yes, was the person of a religion that is relevant for this purpose, which is Hindus, Jains, Sikhs, Buddhists, and Parsis? If yes, was their will executed in a specific area, and I'll come to that area, or did the will deal with immovable property in those areas? And now, what are those areas? Those are Mumbai, Chennai, and interestingly, and not too many people know this, people think it's only Calcutta, but actually the law says for Hindus, Sikhs, Buddhists, and Jains, it covers all of the area which on 1st September 1870 was subject to the jurisdiction of the Lieutenant Governor General of Bengal. So that includes not just Calcutta, but in fact there is some judgments in jurisprudence to suggest it goes as far as Patna and other places in Orissa, Bihar, and Assam. So if all of these three tests are met, then the provision said that you need what is called a compulsory probate. If any of these tests are not met, for instance, if the person is Muslim or Christian, or the will was executed outside of these places that I have mentioned and didn't deal with immovable property, then probate was not compulsory. So just to give you an example, if there is a person who is living in Delhi and has family in Mumbai, if they had executed their will or signed their will in Delhi, then the compulsory probate would not apply to them. But say if they had family in Mumbai and went to meet their family and signed their will in Mumbai, then without their knowing possibly, the compulsory probate provision would apply to them. And so, what is compulsory probate? Compulsory probate doesn't mean that the will would be invalid. Like a will which is generally valid would not become invalid merely because a probate has not been obtained. The law is slightly nuanced and technical. What it says is that if you were an executor under the will, or a beneficiary, or a legatee, a person who receives benefits under the will, if you had to go to court and claim your right under the will, then you would not be able to do so unless the will was probated. So it's slightly technical, it's a slightly nuanced situation. With effect from December 20th, 2025, which is some days ago, this provision has now been amended and repealed, which means it no longer exists, which means irrespective of whether you're Hindu, Muslim, Christian, or whatever religion you belong to, where you sign the will or where your immovable property is, you will not be required to get a compulsory probate.
So functionally, therefore, Shaishvi, how does this change things? Because I've heard situations where people have to wait for months together to get a probate approved. And this goes to 6 months, 7 months, and it's time consuming, especially in a situation where sometimes this is a time sensitive matter.
Yes. So 6 months, 7 months, if you're lucky, Alex, I've known of situations that go on for many, many years,
Yes.
unfortunately. What this changes is let's think of how it changes for the different stakeholders. For people who are inheriting under a will, the heirs under the will, the process potentially could be quicker for them because now the executor doesn't have to go for a probate. But, and this is where all of the nuance comes in, is there are still some assets for which a probate may be required. For instance, if the person has passed away, leaving a bank account, for instance, or a demat account where there is no nominee and no joint holder, then as per the RBI and SEBI guidelines, above a certain monetary threshold, the bank or the depository participant is entitled to seek a probate. Or for mutual funds above a particular threshold, or if you're trying to claim PPF. So, in all of these situations where there is a nominee or joint holder, then a probate may not be required. But if there is none, then those institutions are authorized to do that to ensure that they're releasing the money and the assets to the right person. The other place where we sort of need to think about this is immovable property, real estate. Till now, if a person had inherited property in any of these places that I had mentioned, and they had a probate and they wanted to sell that property onwards, the buyer would ask for a title report. The lawyer who makes the title report would examine whether there is a probate or not. If there is a probate, then very often the title report would be clean. Banks would also rely on such a title report when financing, giving a house loan for the buyer to buy that property. If the probate provisions are gone and there is no probate obtained by the person who wants to sell this property, I think it remains to be seen how buyers and banks are going to look at this. Would they be uncomfortable buying a property or lending to a buyer who is going to buy a property where probate has not been obtained?
Okay.
So that's, yeah.
So therefore, in that scenario, so just to complete that point, Shaishvi, and I'm trying to understand how it would work right now. If I'm, so you would look for the title document, right?
Yes.
So you're saying that it would not be possible to make a title document without a probate now?
No, I'm not saying that. I'm saying that if there was a probate, then the person who's buying it would be very comfortable saying this will is genuine.
Sure.
Without a probate, they don't know if the will is genuine. And so then they also don't know if there is potentially a likelihood of a challenge to that will. Is someone likely to get up and say, no, this will was invalid, and therefore the person who's claiming to sell the property was not entitled to it? And the interesting thing there is that typically these title reports are also run for 30 years because if there is a minor at that time when the person died, that minor has 18 years of his to till he becomes a major and 12 years after that. So it's pretty much a 30-year question mark on whether that title is valid.
So, and this is a layperson asking a question, Shaishvi. So I'm just trying to understand this. Hypothetically, if
Yes.
a transfer through a will has been done, I have gone through the necessarily legal steps to get it registered in my name. Okay.
Yes,
So
correct.
therefore, the ownership has shifted to me.
Correct.
Would I still, therefore, in that title, require probate, or can it? No. In that case, I would not. Right.
You would not. So the law as it stands right now, you would not require. So that is a very helpful amendment that has been made. even if you look at, say, the Maharashtra Cooperative Societies Act for flats in Mumbai, that was amended a couple of years ago to provide that probate will not be required. You can do a transfer. The society or the authorities are permitted to do a transmission of the property on the basis of a will without insisting on a probate. I think where the practical aspects of this will come in, and not the legal aspects. The title report aspect is more of a practical aspect. If a buyer is buying a property where, say, a probate is not there, are they likely to be slightly wary if there is no stamp on that property that the will is genuine?
Okay. And final point, is there a monetary aspect to this? Because as I understand, there's a court fee involved in acquiring a probate as well, right?
Correct. So, Alex, just to say that what we've discussed till now, we've said compulsory probate is out, but you can still apply for a voluntary probate in situations where, like I said, a bank asks for it, or DP asks for it, or if there's likely to be a challenge to the will, you can seek a probate. There is, when you make that probate application, there is a court fee that needs to be paid. In Mumbai and Chennai, there is a cap on the court fee. In Mumbai, it's 75,000 and 10,000 for widows. In Chennai, it's 25,000. But in other parts of India, there necessarily isn't a court fee cap. For instance, Calcutta and Delhi don't have court fee caps. And the court fee then depends on the value of the estate, which could run at anything from 2% to 5 or 6%, which is quite high.
Wow, that's quite dramatic. Okay, so, but I think the good part is that the choice now rests with the individual, and you can choose therefore, and therefore it's a relevant update to the legal system. Shaishavi, thanks so much for explaining this. You've also explained why someone might still want to go out and get that probate done.
Yes.
So thanks so much for taking the time.
Thank you. Thank you so much, Alex.